Welcome everybody. Thanks for joining us today and watching this episode of sort of like it's a combination podcast slash webinar because Joe and I'm going to introduce Joe in a second. Joe and I were planning to do a webinar or maybe even a seminar for our clients on a topic of wills and estate planning. At the same time, as you know, I'm doing a lot of podcasts with specialists in different areas. So we're going to merge that today together. And we'll just start off with, asking Joe. Joe's a lawyer that I met a little while ago, and we've been working together on some clients. So Joe, just tell us a little bit about yourself. What's your full name? What's your corporation name? And what do you do?
Thank you, Serge. Thank you for having me today. Well, my name is Joe Lavalle. I'm a licensed lawyer here in Ontario. I have my own firm. I started and run my own firm. It's called Lavalle Law Professional Corporation. I've been practicing for several years now. The main part of my practice entails real estate law, wills and estates law, and corporate law as well. I do things in between, however, that's the bulk of my practice, and that's how I assist my clients best in those fields. I am in the Vaughan area, Mississauga area, and I am starting to branch off in the Keswick area as well.
Okay.
So I do have an office there as well. So I try and do my best to meet all my clients' needs and help and serve the GTA as a whole.
So people in Sudbury, sorry, we don't have a satellite office there quite yet, but
not yet. But with the implementation of Zoom and Microsoft Teams, we could do a lot of online. A lot of DocuSign. With new technologies every day, we have a great opportunity, and we can really extend our reach.
Gotcha.
And we can help better serve everyone, really.
Okay. Without putting you on the spot, I know that you do a lot of legal work in different areas, real estate, wills and estates, corporate, you said. Is there a specific type of client that you're best suited for, or that you work with a lot, or is it just whatever, legal needs are needed in that area?
Well, it just depends on kind of what hits my desk. Right. I'm happy to serve everyone with respect to whatever their need may be, whatever their legal need may be. I do get requests and I do get inquiries for all types of law, to be honest with you. But I found the bulk of my practice is still the real estate area. As we all know, the market is continuously growing, right? The demand is there. And I do see a lot of clients in the wills and estates department, whether it be wishing to draft a will, a power of attorney, or in the more unfortunate event would be during the probate process, helping family members, right, deal with the passing of loved ones and the next steps.
Okay, so let's dive into that. How important is it that people have a will?
Well, I would suggest that it's very important to have a will, because if you have property or other assets, and it doesn't have to be a lot of assets, it's necessary to make sure you safeguard your estate for your future family, or your children. And I can understand that thinking about writing a will can be an unpleasant thing, and it tends to be a back burner item for most people. Unfortunately, most people most individuals don't see the problems that arise when you don't have a will. I like to say that we need a will, so at the end, it is clear of how you want your assets to be distributed.
Okay, so you want to jump to what might be the repercussions of not having a will?
Well, from what I've seen, this usually leads to family squabbles. Okay. This then results in the estate being put on hold and can be left motionless for years. This means that no part of the estate is distributed to family or friends. Without a will, the distribution of your estate is left in the hands of legislation, and its decision can be completely contrary to your wishes.
Okay. So, I think I want to go back. I'm trying to think from the point of view of a potential client or prospective client. When we talk about assets and properties, I know it's our kind of industry lingo, but uh, what are we talking about when we're talking about properties and assets? Are we talking about houses? Are we talking about RRSP accounts? Are we talking about gold in a safety deposit box? What exactly are we talking about as assets? A
Well,
painting
that's
on a
great.
wall? Like,
Yeah,
what is
that's a
that?
great question. It's all encompassing assets, really. Um, the way my office, my practice operates, we make sure that all assets are included in our will, okay, and our estate planning. So whether that be an amalgamation of everything, whether you wish to make a specific bequest to a certain family member over another, that would be something important that we would list in the actual will itself, whether it be a piece of artwork or a family heirloom or a car. Maybe you had your grandfather's watch that you want to provide it to your grandson, right? These are specific items that we can really put in our wills and make sure that they get into the hands of the people we wish for them to receive.
That makes sense. Okay, so now in my situation, we don't have children. My wife and I, we do have a will. We believed in will for a long time. Um, but we've got each other as joint or beneficiary for each other. How important is it for someone like us to have a will as well? Um, if we don't have anybody else we're really concerned about afterwards.
Well, it's important, I would say, in that sense, regardless if you have children or not. As I said in the beginning, if you have property, right, you want to make it as easy as possible or as streamlined possible for the loved one that's still living to receive your assets and to have property carry over automatically, right?
Gotcha.
If you don't and you don't have a will, probate can ensue. And without a will, the probate process, when you're applying to the courts to be appointed as an estate trustee, can be a 6 month to a year long wait, just
Well,
because of the backlog the courts are facing right now. So I would suggest that it better safeguards your loved ones,
I do want to
regardless
get
if
to the
they're.
probate. Yeah, I want to get to the probate question, but I was wondering, what can you answer this question? What happens when uh, my wife and I both pass, and you know, if we don't have a will, does it go to the government? Does it go to, like, what happens if I don't have anything like in a will
Well,
or something?
that's the thing. It's left to the courts to decide, right?
Okay.
And someone within the family may have to step up and say, "Hey, I am connected to this individual in this way. I would like to be appointed as state trustee in order to manage the estate and the affairs of the estate."
And could they
And
then decide that they deserve the property,
well,
or
they
is
they
there like
could
rules?
they could, and it can go into the hands of maybe family or friends or individuals that you don't want. So
Okay.
if even if you, for example, don't have children, but you're very charitable, right? You may wish to put whether it be a portion or the total of your estate to maybe Sick Kids Hospital or some kind of other
Right.
important organization. And if you don't, or if an individual doesn't outline that in a document such as a will, the money in the estate could be mismanaged and
Okay.
misused.
So it really
Definitely.
gives you the opportunity while you're alive to clearly uh, explain exactly what you want to happen after you're gone. And it might
Exactly.
be simple at the beginning if it's husband, wife, it's going to go to the spouse. But if something should happen when you both pass away suddenly, then what happens with all that stuff? I know that we're gone at that way, so it's not really an issue
But
for us anymore. But
yes.
if we wanted to make sure that it was clear that it's going to some organization, or maybe deciding on some family member or a trust,
Well, we all
then
have, Serge, we all have siblings, right? We all have friends, right? So if it can't go to our next of kin directly because we don't have any children,
yeah,
right? We may wish for it to be passed along to our brothers or sisters,
yeah,
right? Maybe we have nieces and nephews, right? These are all individuals that can really benefit and have get a positive impact as well from the benefits of our estate. right?
So, yeah, that's true.
We've worked so hard for what we accrue over our lifetime. And to be honest, my thinking is this: it'd be such a shame that it would be left in the hands of the court, because then not only it could our assets could fall into the property of someone else that we may not have wished for. It also costs money and time, and you will bleed out and exhaust the funds of the estate in order to make this decision, or for the court to make this decision.
Yeah, it'll all be paid to lawyers and courts, right? Right. So listen, we talked about probate a little bit. What's that elephant in the room? Everybody says, I don't want to pay probate. I don't want to pay probate. Like, can it, touch on that in a broad scheme of things? What is that?
Sure, of course. So probate in Ontario currently is a 1.5% tax on our total estate. Okay. It doesn't matter whether we have property, other assets, investments, things like tangible items like artwork or vehicles, jewelry. If we don't have a beneficiary listed to receive those items, whether it be a title of a property as joint tenancy, where the surviving spouse or the surviving person on title automatically assumes the interest of that property. If we don't have something in place like that, then we're subject to probate tax, and we're subject to going through the probate process, which I explained is a 6-month endeavor, unfortunately, just because of the backlog we see in the courts currently.
But doesn't probate have to be done on wills anyway, or?
Correct. It does. What happens is the banks are usually the contributors of that, and they initiate that process because they would like the courts to vet the will.
Gotcha.
Meaning that they want to ensure that our trustees or executors that we have listed, our family that we have chosen to be our personal representatives in with respect to our estate documents, they do have the authority to manage our affairs and manage the testator's assets on the behalf of the estate.
Okay. I mean, at the risk of running out of time, because I know this is a short session today, I really want to dive a bit more questions on this side, and then if we run out of time, we can maybe do another session. But for probate, because it's always been a question for me, like I've told my clients, yeah, probate is the courts making sure that it's the last will and testament so that it can be valid. Do you know exactly how they do that? Is there like some registry or something, or what happens how do they know that it's the last will and testament?
Well, while we're alive, usually wills don't get registered. Okay. When they're drafted. It is only when we go through the probate process is when they're registered in court, and it goes before a judge, and the judge makes an order based on the will of the estate, where things can be devised as per the estate and as per the will, keeping in mind these are the representing parties, the trustees that we have chosen to manage the affairs of the estate.
Okay.
From this, we get a certificate of appointment of the estate trustee, or a probate certificate, as most people know it as, right? So once this is received, usually following a few months or so, the family member or the estate trustee can then use that certificate to go to the banks and to deal with the affairs and receive any benefit from the estate if they're also the trustee.
Okay.
And if
this is a big area. I think there's gonna be a ton of questions coming on this, because I know I'm already hearing my clients' questions that I've had in the past. Like, for example, like you said, at 1.5% in Ontario. So correct me if I'm wrong. If you're listed as the executor on the will, it's your duty or responsibility to list the assets and submit it to the courts with the probate so that they can clarify the fee, right?
That's absolutely correct.
Okay.
We trustees, executors, they have a fiduciary duty to make sure that everything is done in accordance with the will. Okay, so if that means all debts need to be paid prior to any beneficiary would be receiving any of the assets, right? That means they have to compile an assets list, whether it be from the bank or financial advisors, They will have to make sure that everything is in line, and these are the assets, and these are the assets with beneficiaries, and these are the assets without beneficiaries. And those assets without beneficiaries listed in this asset list, usually provided by the bank or another financial institution, that clearly shows what would be subject to probate tax or not.
Gotcha. Well, this is a very deep topic, so I think let's park this for now, and I'm sure we're going to talk more about this at a future date. But let's talk about also another important aspect of this whole wills and estate. Like when you get a will with a lawyer, do you also get at the same time the power of attorneys? And can you talk a little bit about what that is?
Of course. So my practice is this: when I have clients come in and to do a will or to draft their estate documents, I always recommend and suggest a power of attorney. Okay. A power of attorney, we have two currently in Ontario. One for personal care, deals with our health, deals with making appointments with our physicians, and then we have a power of attorney for management of property. So that deals with all our property, that deals with assets we have within the bank. A power of attorney, as maybe some already know, is a legal document that gives someone else the right to make decisions on our behalf. Okay. I like to think of it as a type of insurance. It's a plan for when you are incapable or at the moment in time when you cannot deal with your affairs. And since no one really knows at which point in time they may or may not be incapable, it's usually good practice to have a power of attorney done when writing your will.
Okay. Can you get a power of attorney after someone has lost capacity, or is that impossible?
No, that would not be possible. When we do a power of attorney document, we must have the understanding of what we own, right?
Gotcha.
Our obligations we owe to our dependents, if we have any, right? We have to be physically and mentally sound of and mentally sound of mind. We'll cut that if you don't mind, Serge. Thank you.
Yeah, no problem.
Start again. When doing a power of attorney, we have to be sound of mind. We have to be mentally capable of understanding what assets we have, what obligations we owe to our dependents. We have to be sound of mind and capable to really understand what we're reading and what we're signing. Yeah. And if that point of incompatibility has come up, then it's impossible to create a new document at this point in time.
Okay. Now, here's a question that comes up a lot when I talk to my clients. I ask, "Do you have a will?" And they'll say yes or no. But then the next question sometimes is, "What do you think, Serge, about those will kits? That do I have to talk to a lawyer?" And what's your response to that?
I hear this a lot. Well, with respect to creating our own will kit, I would say to be wary when doing something like this through a program.
Well, of course, you would say that. You're the lawyer, right? But why?
Well, I have some substantial evidence to back this up. Usually, what we can see through a will kit, it's lacking a lot of clauses, important clauses. Okay. If it's not done correctly, we are subject to the discretion of the court system, okay, which could later bear more costs, time, and risk to the family left trying to deal with the testator's estate, right? I've always had a bit of difficulty wrapping my head around the idea that people try to save money on planning for their estate and the distribution of the property and assets when they've worked their entire lives to put all of these assets together, right? And when it comes down to it, we have a lot more assets than we think. So why take the risk?
Yeah, good point. And the thing is, you really don't know. It's like, actually, let me cut that there because I was distracted by the phone and beeped it.
Oh, no problem.
Let me look at this question next. Okay. All right, good advice on seek the services of a lawyer to talk about getting a proper will and powers of attorney. Now, uh, last question of today: when do you recommend reviewing or updating a will?
Well, I would recommend reviewing or updating your will when you have a major change of life event. Um, whether that be a new family member coming into the picture, whether a new child or a new grandchild is born, right? You may wish to make that amendment to include that child inside our will, right?
Mhm.
Usually with testators and will makers with small children, I always recommend a guardianship clause,
Mhm.
right? So that guardianship clause basically entails in the event that both parents shall predecease that minor child, who would you like to choose to take care of that child and raise that child, and at the same time, who would have carriage of that child's assets,
Right.
right? And we want to make sure that all the children are included in that, and I like to include them by name because I like to be as specific and detail oriented as possible, and we want to make sure that everyone is accounted for and everyone has uh, equal representation as long as the testators are devising everything equally to the children, right?
Yeah. Yeah.
Um, and any major life change like that, whether it be a large sum of money coming in to the picture, right?
That's
Um, it's quite important in that sense.
Yeah, I think it's true that people don't actually think about a lot of these and the will. Most people, I shouldn't generalize, but I guess I get the sense that a lot of people, we've done the will, it costs some money. We've done it, it's in the safety deposit box. I don't have to do it anymore. But what you said is very true. Like when things change, marriages, divorces, uh, new family members, it would be important to update that. Otherwise, you could be looking at probably another family squabbles down the road.
Of course,
Yeah.
and as long as the lawyer is fair, we also have the opportunity to do a codicil. Maybe we'll take that out, Serge.
Yeah, no problem.
That
Do you
fair
wanna do you
part.
want me to ask you if there's like what's the general cost of wills or not, or do you want to leave that off the
No,
table?
let's leave that out.
Okay.
Let's leave that out.
All right.
And maybe can I mention about the codicil? I was going
Yeah,
to mention a codicil. It's a one-page amendment, and it's a lot more cost effective than a
sure.
will.
Go ahead. Yeah.
Okay. Um, another point to add, Serge, is when we're thinking or determining whether we need to revise our will or amend our will, if it's a small change, we can do something as lawyers called a codicil, which is a one-page amendment that basically fits into the original will. So you're not revising and changing your entire will. It's just it's an edit where it basically substitutes one paragraph for another, and it's a lot more cost effective to the client.
Okay, that's great. That's so you don't have to go through the whole process, just adding another one page to the document. So hey, I
Correct,
got a new
correct.
grandchild. This is what that this grandchild fits in, kind of thing.
Correct.
Yeah.
And it continues with the existing will. It doesn't nullify or void the original will. It's an accompaniment.
Joe, thank you so much. There's so much information. I have questions keep on popping up. I want to wrap it up, but before I do, I'm going to throw out a question maybe you're not prepared for. Oh, don't sweat it. Don't worry. It's just a fun question. What does Joe like to do for fun?
Well, when I'm not working, I like to spend time with my dog. I like to spend time with friends. I like to be physically active, whether it be at the gym or doing sports outside.
Awesome.
Um, yeah,
You,
that's a little bit
this
about
is
me.
another trend. I spoke with another person on a podcast, and it's true. A lot of the professionals that I work with that are building businesses, physical fitness and health seem to be of paramount importance. So that if you can take care of yourself, you can take care of others.
Of course, I agree. I agree, Serge. You have to take care of your mind. You have to take care of your body, or else it's a challenging field, right?
Yeah, yeah,
Any kind of professional field is a challenging field. So you have to make sure you take care of yourself first, as you said it perfectly, you cannot take care of your clients properly.
Awesome. Let's end it on that. Thank you so much, Joe, for joining us today. Actually, what's the best way that people can find you? I'll make sure that we'll having posted on the description below or somewhere, but what's the best way that people can find you?
Well, people can find me on social media such as LinkedIn, Instagram.
Okay.
I do also have a website, www.lavallelaw.ca. Um,
Okay. And a phone
I'm
number?
and the best phone number to reach me at would be 416-659-8073.
Great. All right. Thanks, Joe. Appreciate the
Thank you for
time you've
having me,
given us
Serge.
today. I'm sure there's going to be tons of questions. If they do come in, I'm going to be calling you to set up another session. And perhaps, who knows, maybe we'll do something more engaging and in person if there's enough interest down the road. What do you say to that, Joe? Is that okay?
That's exciting.
No,
That's
I've
exciting.
got it.
I'm
I've
happy
got
to
it
continue.
legally recorded, so I've got you now.
No, my pleasure. It would be my pleasure. Thank
All
you,
right, Joe.
Serge.
You have yourself a wonderful day. Thank you very much, everybody, for watching, and have a great day.
Thank you.